All right. Thank you so much to everyone for coming to. This is now the third year that we're running this event, and it's always incredibly well attended and helpful. Before we start, some housekeeping. This event is not a women and family law members only event. It's been open to everyone because we wanted to try and help as many people as possible during the pupillage interview season. But if you are interested in joining women and family law, you can find details on how to do that on our website, womeninfamilylaw.net. We run events throughout the year. Some of them are virtual, some of them are in person, and they run across the country. So details on how to become a member eligibility are all available on our website. So today's event, thank you so much for attending. We've had such a great turnout yet again, but this year we have mostly a new cast of characters. If you haven't been to this event before, we run 2 mock interviews for you to observe, one which is children law focused and one which is finance law focused. I'm going to let the panelists introduce themselves briefly before we start with the first interview, which is going to be the finance law one. There will then be a Q&A at the end. If you don't want to ask any questions openly, because we're now recording this session, you can direct message me on the Zoom chat function and I can ask the question for you. All right, so I'm going to ask Gwyn to introduce himself first, please.
Good evening, everyone. I am Gwynfor. I am a barrister at 36 Family. I specialise in financial remedies and trusts of land. I have just been appointed a Deputy District Judge on the South Eastern Circuit, so that I have to look forward to as well.
Thank you, Gwyn. Rachel?
Good evening, everyone. I'm Rachel Bloxwich. I'm a barrister at 3PB based in Birmingham. I have a mixed practice of financial remedy and private children law work.
Alex?
Hi everyone, I'm Alex Hampton. I am a barrister at Queen Elizabeth Building. I'm probably the most junior barrister on the panel. I started my tenancy in 2021, so I last interviewed in 2019, and my practice is still broadly mixed between financial remedies and private children law, but specialising increasingly in financial remedies.
Millie?
Hi, I'm Millie. I am a specialist family law barrister from 1 KBW or 1 King's Bench Walk, whichever you prefer to call us. I will be 10 years core this year, and I actually, since coming back from maternity leave, pretty much only done finance work, but before that I had a very mixed practice, and I still do all areas of law, just mainly finance work.
Clarissa?
Hi, good evening. My name's Clarissa Wigoder. I'm a barrister at 4PB. I'm a specialist children practitioner, so I do all areas of children law, public, private and international, and I'm about 4 years core.
And finally, Charlotte.
Hello, my name's Charlotte Hughes. I'm a barrister at East Anglian Chambers. I only do children work. I don't do any financial work, and I was called in 2017, sorry. You lose track after a while.
And I'm Malvika Jaganmohan. I'm chairing the event today. I'm also a family barrister specialising in children law work at a set in Birmingham. All right, so without any further ado, I think we're going to launch with the finance-focused interview with Rachel, Gwyn and Alex. Can I ask everyone to turn off their cameras and mute themselves if they are not one of those 3 people? And then I'm going to spotlight Alex so that her face can fill up everyone's screen and they can focus all their attention on her. Right, so I think Rachel and Gwyn are leading this particular interview.
Well, good evening, Alex. Thank you for coming to see us. Why family law?
The honest or flippant answer to that is that I'm a little bit nosy. So I enjoy finding out about people and their lives. And I think that as a way into a set of papers, when you're sort of first doing a case, you get a whole new set of facts, you get a whole new set of people, and you get a really unique insight into the way that their lives are, and you get to support them through a time where perhaps their lives aren't going exactly the way that they wanted to. And as against other areas of law which sort of look backwards, so looking at working out what's happened and any remedies that arise from that, family law, as far as I can see, is very forward looking. So you're looking at how you can sort something out to put both parties or multiple parties on a best foot going forward.
Well, Alex, I'm conscious that you've just graduated, and so do you feel equipped to advise clients on some of the most traumatizing issues imaginable?
I think the reality is that, yes, at the start, that's going to be difficult. I think what's important, as I understand it, is to focus on the fact that I'm not there to fix absolutely everything that's going on. I'm there to maintain a degree of objectivity. And the best thing that I think someone can get out of a barrister is someone taking a step back and looking at the situation as it is objectively, whilst also developing and maintaining that sensitivity when you're giving advice as to how it's going to be received.
Now, my colleague Rachel might have some questions for you as well.
Alex, I was wondering if you could tell us a little bit about the qualities and the strengths that you think that you have that are particularly suited to family work, and particularly in relation to financial remedy work, please.
Of course, so my understanding is that particularly with financial remedy work, there does have to be a degree of numeracy and a familiarity with certain financial instruments. So I did an internship at a bank straight out of university for 10 weeks. Now, I decided at the end of that banking really wasn't for me for various reasons. But within that internship, I did learn how to manage my numeracy skills and to develop building Excel models, for example, in relation to certain products that the desk that I was on was selling. But also B, I had to present over the course of that internship those products and explain them in a clear way and field questions from the floor on 2 occasions in that internship. And that meant that I had to assimilate all of the numbers and have them all in my head, but answer questions in terms of variabilities on those numbers under a degree of pressure whilst I was presenting. And I think that that translates well into financial remedy work, where sometimes on your feet, you'll have to be dealing with certain ifs and buts and whens, to put it that way, around how various permutations of orders might play out with the numbers.
And how about personal qualities? You talked about technical qualities, but what about the personal qualities that you can bring to this type of work?
Of course, I really do believe that one of the most important that a barrister can do is to listen. I'm sorry for everyone involved. You may have found out at the start that I'm dealing with some train difficulties today, and perhaps as an example of where interviews need to be quiet. To answer your question, I do believe that an important quality that a barrister can have is the ability to listen. So to take instructions very sensitively from a client and listen to what it is that they're saying, and then translate that into the best possible advice for them. I have over my time at law school volunteered at a project that's called the School Exclusion Project. So it's where you represent the parents of children who've been excluded from school in the appeal tribunals to both the sort of governing bodies and then on to the local authority tribunals. And over the course of doing that, I had to meet parents on days immediately. We didn't necessarily have a chance to meet beforehand and sit and listen to their concerns in addition to what have been set out in the papers that I'd had, and then present them very quickly. And I think that that's something that will stand me in good stead heading forward for meeting various different people on days at court.
Thank you.
I wanted to ask you a couple of questions about financial remedy work specifically. Do you think that the behaviour of parties in financial remedy proceedings during the course of the relationship should have any bearing on how their assets get divided? And could you tell me why?
My view is no, save for in extreme circumstances. Now, I appreciate that's a very bold statement. My understanding is that that's where the law is at present. But there's a difficulty when you're raking over all of the behaviour between a couple who are separating, and so are inevitably in a position where they're going to think or present the other party in the worst possible light. And the difficulty is that if you want to descend into that over the course of proceedings between parties, that risks raising tensions between them rather than lowering them and focusing them on how to best move forward. And what it might do is impact how proceedings develop between them, it might elongate them and take up a huge amount of time looking at certain, what I'm going to term complaints about behaviour going forward, rather than focusing on perhaps how to place them on better footing. What that doesn't mean is that there aren't extreme examples of behaviour where that has impacted how people are going to have to live their lives going forward in really serious circumstances. So we're looking at domestic abuse, which I appreciate is a very, I hesitate to use the word hot topic in the family courts at the moment, but it is something that we're all increasingly conscious of. And where that domestic abuse has over a long period of time really impacted the victim's ability to A, set out and put themselves on to independent footing going forward, but also B, may well have resulted in them losing out on certain financial positions during the marriage, then I can see how that would really have an impact on what might be considered fair going forward.
Okay. Now, an ethical question I want you to consider. You're representing a client as an FDR appointment, that's judicially assisted negotiation. And the day before that hearing, your client won the lottery. But he doesn't want you to mention this during the negotiations or during the hearing. What, if anything, do you do?
So my understanding of the way that events pan out at a financial dispute resolution appointment is that you have to go and represent to a judge what the financial position of both of the parties is and your understanding of it as the advocate, and also what as a result is the fair outcome as to how to divide what is there between the parties based on various arguments about what falls into what I'm going to call the pot. Because the client has won the lottery, that means that anything put before the judge about A, their financial position, and B, what would be a fair outcome going forward, inevitably flows from what they have available to them. They've got an obligation, as I understand it, throughout those proceedings to disclose the fact, to disclose their financial position and to effectively take a cards on the table approach to it. Where I'm going with that is that, in short, they've won the lottery, which means that they have got this amount of money coming in. Presumably, if it's winning the lottery in this circumstance, in this question, it's a large amount of money, and they have got to disclose it. What I would say is that I would go to my client and say, you have to disclose that, because firstly, A, the other side have got to know it at some point, and we're not going to, otherwise we'll be settling on a false basis if they don't know what the financial position is. But also B, I as an advocate have got to stand up in front of the judge and tell them what your finances are, and I will be misleading the court if I'm not clear on what those finances are when I'm addressing the judge. And if they don't allow me to disclose it, my understanding of my obligations is that I'd have to turn around and say that I can't act for them.
Okay, thank you. That's a very helpful answer. Rachel, do you have any further questions?
I was wondering, in terms of the landscape of family law and particularly financial remedy work, what would you say are some of the biggest challenges facing practitioners in this area of law?
We've already touched on it at one point during this interview, but looking at our changing understanding of domestic abuse and how that might impact A, how we deal with our clients going forward in terms of being increasingly aware of the vulnerabilities that they may have, and therefore, for example, in the course of the negotiation, the differing pressures that they might face, but also B, the outcome or how that might influence the outcome going forward based on what we know now, and is this increasing awareness of where financial abuse in particular can have a long-standing impact on someone that isn't necessarily obvious from papers that we will look at. I think also there's the issues that are coming increasingly to the fore, and we're seeing, I understand it's being seen increasingly in financial provision for parents of usually predominantly caring parent and child where that couple hasn't been married, because there is a disparity in the remedies that they can seek from a court, and it's whether or not within the modern world and within the fact that there is a reducing rate of people getting married, whether that is A, fair, and B, how we can, whether that needs reforming.
Now, if you couldn't be a family barrister, what would you be, Alex?
I would, in an ideal world, be a TMS, that's Test Match Special cricket commentator. I think it would be very fun. I'm not saying that I'd be able to do it, because frankly, I think that their ability to talk for days and days on end about the mundane is perhaps not something that I'm necessarily the best at. But to be able to sit and watch cricket and go around the world would be what I want to do.
And another legal question for you. Do you think that cohabitees, or maybe this is more of a policy question, should have the same rights as married couples? So rights to property orders and lump sum orders and maintenance orders and so on?
The difficulty with equating those rights is there are questions about how do you qualify. Cohabitees could mean we've lived together for 6 months, or it could mean we've lived together for 14 years and not been married. And actually, there's a policy question mark for the government to consider as to how you define that sort of period beyond which you suddenly graduate to this new special class, quote unquote, of rights. And similarly, we have got an acknowledgement, and perhaps this is a traditionalist approach, we've got an acknowledgement under our law as it stands that the decision to get married and to enter into that marital partnership is a decision that is open to everyone to take should they choose to. And we then afford that partnership certain additional rights over the course of the relationship. For example, the ability to transfer the tax-free allowance to your spouse when one isn't working, that mean that those benefits are there during the relationship, and therefore when it breaks down, we've ascribed a different set of rights to them. I am actually on the fence about how you would go about doing it, because day to day you can see that when couples who've been in a long-standing relationship and have children but never got married, when that relationship breaks down, it can leave a party in a really weak position for which there's very little remedy or limited remedy at present. My concern is how you then practically implement that alteration in rights that you afford, and how that would effectively open the floodgates of certain arguments around what constitutes cohabitation, how long that cohabitation has to be for before you qualify, which is a decision for policy and legislators to take.
How long do you
how
think
that
it
would
should
then
have to
work
be?
on the ground. It's plucking a number of years out of thin air to say whether it's 5 years, whether it's 10 years. You want to get out and say it was a substantial amount of time, but that is ducking the question. I would probably say for at least 5 years.
Okay. There's a lot of talk in the law reports in the family courts about solicitors' hourly rates at the moment, and I wondered what your views were as to whether those should be capped in financial remedy proceedings so they can only recover a certain amount of money.
Capping the hourly rate, there's one argument to say that ultimately it's the free market, and if a party decides to go and pay a certain amount of money for a solicitor, that there is that sort of market competition that solicitors are allowed to charge for. In terms of capping then the ultimate costs at the end of proceedings, there's a difficulty in looking at the needs. For example, some clients require more interaction with their solicitors than others and support through proceedings, depending on whether they're the ones who understand all the finances and proceedings or don't understand the finances and proceedings. I don't think that it's necessarily a cap that needs to be imposed, but in terms of looking at when the court looks at cost orders at the end of proceedings, there is still that discretion as to how much they consider as reasonable to recover, and at that point there's judicial oversight without imposing a straitjacket on capping the specific hourly rate rather than looking at the bigger picture of the case.
Thank you. Rachel.
Alex, can I ask about nuptial agreements and your views on those? Are they a good idea? Should we all be having a nuptial agreement? And where, if you do think they are a good idea, where does that leave us as family lawyers in terms of whether there will be any work left for us in the next 20 years or so?
Well, there are really two questions there. One is, should parties enter into it? And the second is, if everyone does, should they be upheld? And will that leave us with work? Because where the law is at the moment in terms of upholding nuptial agreements is there is still the get out, as I put it, for judges when looking at them, which is, are the terms fair and should they be upheld? Or does it leave a party actually in a predicament of quote unquote real needs such that the nuptial agreement goes in the bin and we look at this afresh? I think it's sensible at the outset of entering into what is and we look at it when it breaks down a financial partnership, setting out the sort of broad terms on which you're going to enter into it. It can help avoid long arguments at the end of a marriage. If it does break down, each party knows broadly where they stand. That being said, you can't account for every single eventuality and every single twist and turn, and that's where that fairness point be upheld, unless court will look at the agreement and was it entered into fairly, and then later on, and are the terms still fair in broad terms, really does leave enough of a discretion for judges to account for the fact that the agreement can't deal with every single circumstance, whilst also still providing broad certainty.
Thank you. Can I ask you perhaps a more personal question then? If you could go to dinner with anyone, alive or not alive, who would it be and why?
I think broadly, sorry, 1 second. Apologies about that to everyone who's on this call. The question was, who could I go to dinner with and why? And I would say probably Ian Hislop, because I think he'd just be a very good dinner party guest. He seems to have a decent amount of wit and be able to argue both sides of the point.
Okay, thank you very much. I think I'm going to bring that first interview to a conclusion and unpin Alex as well, if I can work out how to do that at some point. Bear with me. There we go. Thank you so much, Alex. I'm not going to hold you if you've been trapped in that Costa and you need to get home. And for everyone who's just joining, Alex unfortunately had train issues, which is why there was background noise during her interview. But I'm very grateful to Alex for being able to join us. So I will let Alex go. And just housekeeping for anyone who's just joined, because I knew that I know that I was admitting people as they were joining during that interview. We had an issue with the link last minute. A new one was circulated. We tried to transport as many people from that link over to this one. But if you've missed a significant chunk of this event, we are now going to be endeavoring to record it. Whether I manage to achieve it is a different point. But hopefully that recording can then be made available to anyone who missed the first part and missed Alex's interview. All right, so I'm going to release those three panelists for the time being. Oh, say before Alex leaves, we did make provision in our schedule for feedback. So are there any particular things that you thought that Alex did very well that you wanted to highlight?
I thought Alex stayed focused on the question, which was a good thing to do. There were several questions that she broke down into two stages. So the nuptial agreements question, and I thought she dealt very well with some questions that I thought were rather harder and probably wouldn't get asked to pupils necessarily. So the one about hourly rates, but I was interested in her views. So thank you for that, Alex.
I would agree. I also thought it was helpful that Alex referred back to the question during the course of her answer, just rounding things off. And I would echo the technical points. Obviously, that was the technical answers were obviously answered very well, and you wouldn't necessarily expect that at a pupillage interview. But I think it was really helpful to kind of see the flavour of the types of questions that are asked around policy and things like that.
I think we'll come back to that because we always get a question similar to that in the Q&A where people get very frightened about the level of technical legal knowledge they need to have. I think Millie frightened the daylights out of everyone last year when she blitzed through her interview. So we will come back to that at the end of the Q&A. So I'm going to release Alex. I'm going to ask Rachel and Gwyn to turn their cameras off until the Q&A. And I'm going to ask Millie, Clarissa and Charlotte to turn their cameras on. And then I'm going to spotlight Millie and leave you all.
Hello, Millie. Thank you for joining us today. My name's Charlotte Hughes and I'm joined by Clarissa Wigoder and we're interviewing you today. We're going to ask you some questions first and then there will be some time at the end for you to ask any questions you may have. So I'm just going to hand over to Clarissa to ask you the first question.
Hi, good evening, Millie. Thanks for coming in. Just to start with, can you tell us why do you want to be a family law barrister?
Well, obviously I'm at an early stage in my career and I have to say it's really a difficult decision that you have to make early on because You don't get a lot of experience in each individual area of law, but I think the process that I went down was something like this, that I decided early on, and I knew that the reason I wanted to be a barrister was because I wanted to be in court a lot, and I really enjoy the idea of being an advocate, speaking in court, trying to persuade, doing most of my job in court. And once you decided that, it seems that helps you to narrow down the areas of law that might be of interest to you. And really it looks like sort of criminal law, family law, maybe immigration law, and maybe employment law are the sorts of areas where you're going to be doing more oral advocacy and less in terms of written advice. And then I set about going to mini pupillages, and I did a mini pupillage with Duncan Brooks at QEB, and from the moment that I had done that mini pupillage, I knew that family law was the right area for me. I loved the fact that it was so personal, and that people were coming to you for real help and real advice that they wanted to use to move their lives forward. They weren't coming to you kind of having been sued or having been arrested. I think that you meet people at a really interesting stage in their life. It has a really unique mix of the personal and the legal. And since then, I've really dedicated myself to looking at lots of different areas of family law and trying to find out more about that. And I think it would really suit me as a person and match my interests well.
Thank you, Millie. A bit more of a personal question about you now. Could you tell us what is your biggest strength and what is your biggest weakness, please?
I will start with weakness, and that is that I am a procrastinator unless I have a real deadline. If I have a really strong deadline, I will absolutely meet it, but I need the motivation of a deadline to get me to do things. And I think to some extent, I will be assisted by what I gather is the high intensity family law work, that you do have very solid deadlines and the real motivation of needing to file a position statement to appear in front of a judge. That will make me get the work done. But with a very, very long deadline, I can really procrastinate, start, looking at all sorts of different things and finding other things interesting, which I think might bring me on to my strength, that I'm interested. I think I'm a curious person. I'm interested in people, but I'm interested in what's particularly relevant to this interview. I'm interested in family law, and I think if you're an interested person, it gives you a few different skills. You tend to be a good listener and to be able to really hear what people are telling you because you're genuinely interested in finding out the answer. And I think if you're an interested person, it also makes you motivated and self-motivated. You find things interesting and you go out and find the answers to questions. So I hope that those skills will be really applicable to my work in the future.
Thanks, Millie. If I can ask you now just to do a short advocacy exercise, would you please argue for us in just a few minutes that defendants in cases concerning serious sexual offences should remain anonymous?
Yes. The reason that I believe that defendants should stay anonymous in serious sexual offence cases are manifold. First, the very serious nature of the allegation and the inevitable public interest in relation to that immediately puts a defendant's life on hold. We have all seen reports recently of the backlog in criminal courts, and we know that those defendants who have not currently been found to be guilty of any offence at all will have their entire lives on hold and will probably face at least those near to them, perhaps their employers, significant people in their lives finding out about an accusation at a very early stage. We also know, rightly or wrongly, that there are some false allegations made in relation to serious sexual assaults. And given the prejudice in terms of being accused of these sorts of crimes, and the fact that these days we live in an age of social media where those sorts of allegations are impossible to erase, certainly in the long term from the internet, that again would favour defendants remaining anonymous in those circumstances. The other side of it is that we afford victims the right to remain anonymous, and we understand wholly that the victim must remain anonymous, but we don't seem to understand that by naming the defendant, we make it much easier for that victim to be jigsaw identified. So if people know who the defendant is and they know something around the circumstances of the accusation, they're much more likely to be able to...
For mum. No, the doctor.
If you're not one of the panelists, can you please make sure that your microphone's on mute? Thanks, Millie, please continue.
No, not at all. Slightly lost my train of thought. I'll try to pick it up at the next station. You
were telling us about risk of jigsaw identification.
Exactly, and that one of the most important things in our criminal justice system, and I certainly wouldn't argue against it, is the fact that victims of serious sexual offences have a right to potentially lifelong anonymity, and they should feel safe to make those accusations. And I think a big part of that is also in certain cases keeping the defendant anonymous, because the reality is people can look up almost anything online these days and piece everything together. And so in keeping a defendant anonymous, we are also protecting the right of the victim to remain anonymous. I think the dawning of social media has brought this issue to the fore, and given that at the stage that we're talking about during the proceedings for any serious sexual offence, the defendant hasn't been found guilty or not guilty, I believe they should be afforded the same rights as the victim in these circumstances and remain anonymous.
Thank you.
So, Millie, you've just argued in favour of keeping defendants anonymous. We would now like you, in around a minute or so, to argue the converse, why defendants should not be kept anonymous in cases concerning serious sexual offences.
There has been a long established tradition in our criminal justice system, and it's not just based on tradition but sound principle, as I hope I'll go on to demonstrate, that people who are being tried with an offence and charged with an offence are named, that we have an open justice system. There is a vital importance to that criminal justice system of openness and transparency, and a huge part of that is for any offence, and there is no, it isn't distinguished, but any adults being charged with a criminal offence are named, and a big part of this is to keep our justice system accountable and transparent. If we start taking out certain crimes whereby we say that the defendant in those circumstances shouldn't be named, it's not at all clear why we wouldn't move that only to sexual offences, and we wouldn't apply that to other offences that people might be charged with. There's no coherent reason to give anonymity to defenders in those circumstances. It's often said that there are significant numbers of false allegations made in relation to serious sexual offences, but the statistics don't bear that out as being any more relevant to serious sexual offence crimes than any other crime. And indeed, to kowtow to that myth is to place victims of very serious sexual offences in a really difficult position, and to say from the off that we do not believe and we do not accept reports of serious sexual assault where we do believe other allegations that are made. The stark reality is that this is a very gendered offence, and that it is women who are typically not believed, and men who continue to make allegations that are not true, that women are out to make false allegations, that they are out to ruin reputations. The reality is that those incidents are very, very few and far between, and no more likely to occur in a serious sexual assault case than in any other criminal allegation that is made. if we don't keep an open justice system and we don't keep a level playing field across the board in terms of criminal offences and the naming of defendants, we are going to ride roughshod over the very basis of the criminal justice system, which is that people are tried by their peers, that the media can report accurately on a trial, and that the public have a good understanding of the process. I believe naming defendants keeps them protected and keeps victims protected, and that is the right way forward.
Thank you very much, Millie. I'm going to ask you now a more personal question. If you couldn't be a family barrister, what would you be?
I would probably be a landscape gardener. I love gardening and I love flowers and I love being outside. And I also really love listening to podcasts. And I feel like being a landscape gardener, I would be able to listen to as many podcasts as I like and be outside in all weathers and be doing something a little bit more physical, which I think I would enjoy.
I'm going to go back to the more serious stuff now, if you like, back to legal related questions. Should we do away with the presumption of parental involvement in the Children Act 1989? So you may be aware that at the beginning of the Children Act, there sets out a presumption about where it is safe to do so, parents' involvement with the child being something that is beneficial for them. So should we do away with that? And if so, what would you suggest in the order?
This is something that I think I've changed my mind on relatively recently, but as I understand it, there was concern raised when this presumption was introduced that it would undermine allegations of serious domestic abuse or minimise the effects of domestic abuse on children and the harm that children suffer having experienced households in which there's been abuse. And I know that a number of campaigners were very concerned when the presumption was introduced that it wouldn't be balanced well with the welfare principle. And I think I counted myself amongst their number at the time. However, looking at it from two different perspectives, the first is with my real family law hat on. And the second is with my parental hat on, because I've since had a child. So in relation to the first hat, looking at it from a family law perspective, we only really have very small amounts of evidence in terms of what I mean is research and qualitative and quantitative evidence about what works well for children. And one of the most important things anybody who studies child development and child well-being will tell you is that attachment, an attachment theory and a secure attachment to their parents is a hugely beneficial thing for children throughout their lives. So good attachment early on and then consistent attachment to those primary caregivers will give children a really, really solid foundation for the rest of their lives in terms of their emotional well-being and their confidence and their ability to learn. And so disrupting that attachment can be a real problem. And I think when we only have that little bit of evidence and when we look at it in the round of the rest of the Children Act and we see the presumption does get balanced with an overriding weighing of the factors under Section 8 and sort of the welfare checklist, and we've seen it being applied in practice, we see what an important part a child's relationship, if it can be safely and properly maintained with both parents, is for the rest of their life. And I think it's right, knowing what we do about the fundamental psychology of it, that is emphasised as a presumption in the Children Act. And I think probably coming at it with my second hat, which is as a parent, I think one of the things that has really changed my mind about it is seeing my little boy and how he is with my husband and with me, and knowing that however much I were to maybe in the future hate my husband, that can't be allowed and shouldn't be allowed to interrupt my little boy's relationship with his father. He does, I can see very clearly, need both of us in his lives, and that should continue no matter what our adult arguments. So I see it as a noble goal in the Children Act, and I think that's probably changed my perspective a little bit.
Thank you.
Millie, would you be happy to represent a man in family proceedings who's been accused of rape by the mother, and the case he wants you to put is that the mother's lying and has made it all up maliciously?
Yes, it's the absolute fundamental of being a barrister that we are not our case, and it's not our personal views, but that every person deserves and is entitled to a fair trial, equality of arms, and an advocate to present their case. I obviously wouldn't be willing to ever mislead the court or breach my code of conduct, but if my client had a case and the evidence, presumably in this case it would just be a witness statement that he had signed and sworn to be true, that the mother was making it up, he is absolutely entitled to good, full legal representation. And rather than having any qualms about that, I would be proud to be part of a justice system that allowed a proper right to a fair trial, and proper analysis and rigorous analysis of both cases.
Thank you. Can you tell us about a time that you've had to persuade someone of something, and was it effective?
Well, on a daily basis, I have to try and persuade my toddler to get dressed. And I have to say, he's pretty immune to my advocacy skills. But in a more serious context, I recently had to persuade a health visitor that I thought my son was allergic to milk. And I recognised that I was in a situation where I looked like Mrs. Google, and that I had sat around and Googled symptoms and came out thinking I was the doctor. But I knew how important it was. It was important to me, and I was representing somebody whose voice couldn't be heard. I decided that I would try to persuade the health visitor that I was correct about this, because I knew she was the link to getting proper allergy testing. And so I also made certain decisions in trying to be persuasive about how I presented myself. And I was quite keen to avoid the idea that she thought I was just sort of dismissive of her opinion and that had just been on Google. But I explained very clearly what the symptoms were, exactly why I was concerned, and why the right outcome would be to send him for skin prick testing, that was a good use of resources, because in my view, there wasn't any harm in not doing it. And if I were right, we really needed to change his diet fairly urgently. And I was able to persuade her. And previously, on previous visits, she had not believed that my little boy did have a milk allergy. And in the end, when he was skin prick tested, it was obvious that he did have a very serious milk allergy and all sorts of other allergies as well. But it took some persuading and some careful management of how she might feel that I'd been researching things almost behind her back. And I knew that her opinion at the start was not the same as my own.
What do you think it was that made the difference between your successful attempt at persuading her and your previous unsuccessful attempts?
I think probably my own conviction and a little bit of advice from my mum, which is that going into any conversation, you should always know what you want to get out of it. I think previously I had not really known what I wanted the health visitor to do, what I wanted particularly to persuade her of, other than an underlying suspicion that I had. And so I think I went away, did some proper preparation, really the equivalent of knowing the papers inside out. And I knew exactly what outcome I was asking for. And I think I went in much more directly, asked for the outcome that I wanted, and gave the reasons that I thought it was a sensible one, as opposed to sort of talking more around the houses and never quite setting out exactly what it was that I'd like her to do about it.
Thank you.
We're going to just finish up with an ethics question for you. So you are in conference with your client at a final hearing in private law children proceedings, and he tells you that if he can't have the children, no one can. What do you do?
So the things that I'm thinking through in answering this question, I'm thinking first of all about my duty under the handbook, as I understand it, to a complete confidentiality, but also a duty, a safeguarding duty to potentially the children, or potentially his partner in this case. And I'm concerned about how they might clash, because if I take this statement as what it potentially is, which is a very serious threat, either to harm the children or to harm his ex-partner, their other parent, that would raise immediate and possibly, while the risk might be small, the consequences would be huge, safeguarding concerns. In all reality, what I think I would do is what a barrister told me about when I was on a mini pupillage, which is ring the Bar Standards Board's ethics hotline, because it is such a serious judgment to be making, potentially breaching a client's confidentiality. But if that's not open to me, then what I would do first of all is assess with the client and dig in deeper as to what the context of that, and to assess in reality the seriousness of the threat, and to explain to him that I do have duties if I'm concerned about immediate safeguarding of children or his ex-partner, to breach his confidentiality, and explain to him that that's what, if under investigation and investigating it, it seems to me that is a real threat, and has, I have to say, even the merest hint of reality behind it, I would have to explain to him that I'm thinking of breaching his confidentiality and the steps that I would be planning to take, which I assume would be something like contacting the police and the local authority, and possibly even making the other side aware of it. So it would be a really significant breach of his confidentiality, which would be why I'd be so concerned to make sure that I was doing it in the right circumstances, to make sure that I was doing it in response to something that was said with some amount of genuineness, as opposed to a glib, ill thought through, throwaway comment.
Thank you. Is there any difference in your answer as to what you would do if this was in a conference with you pre-hearing, where you had not yet gone into court and had the final hearing?
No, it doesn't matter to me when that threat comes or how. I mean, I'd have to, I suppose it changes somewhat the discussion I had with my client, which is, is this just a response to the stress that you're having about the hearing? And in that sense, it may make my decision, if that were the decision I came to breach confidentiality, slightly different, in that he may be more easily able to reassure me that it was an empty, throwaway, glib remark if it weren't off the back of being denied contact with his children, or not getting quite the contact he wanted. I suppose in those circumstances he might more easily be able to persuade me that it was an unthinking comment and not based on any reality. But I have to say, it doesn't change the ethical considerations that I have, because whilst I'm under a duty of client confidentiality and under a duty to take safeguarding actions if there are immediate concerns for welfare, those apply both pre-hearing, during the hearing, and after the hearing, as I understand it.
Thank you, Millie.
Thank you so much, Millie. Before we finish, have you got any questions for us?
I don't think I have any questions, except a very, very practical one about if it's at all possible when I might expect to hear. I know you've got to see a lot of other candidates.
We'll be doing our interviews over the course of this week, and we'll let you know within about 2 weeks whether or not you'll be invited for another round.
Thank you, I really appreciate it.
Thank you so much for coming in, Millie.
Thank you, Millie.
Right, I'm going to try and remove the spotlight on Millie. I'm going to ask all the panelists to turn their cameras on again, and in fact for everyone to turn their cameras on if they feel comfortable doing so. The Q&A is always better when we can actually see your faces. So again, I was admitting people very late, so I'm sorry if you were late attending this event because of the link error we had last minute. This event is now going to be recorded, or I'm going to try very hard to record it and put it up on our YouTube for a limited period of time so people can catch up if they missed anything. Before we go into the Q&A, I'm going to ask Charlotte and Clarissa if they have any feedback about Millie's interview.
Sure. Some positive feedback in terms of your answer to why you wanted to be a family law barrister. I thought it was a very clever and clear answer. I think the point of that question is really showing a bit about yourself, but also showing you really understand what the job is. And that's something that really came across in your answer, identifying what features of family law, life at the family bar are different to life at different areas of the bar. I thought that was a very clever answer. In her advocacy exercise, I think signposting subpoints within the answer. You know, the first point is this, the other side of that is that. These signposting phrases are really helpful to keep your interviewers engaged, and I thought that was very effective. And I think the example you gave of the time you had to persuade someone of something, the health visitor answer, was a great answer. It was a real life example. It showed that you don't need to have any fancy or legal experience to answer that question well. It was clear in terms of exactly what the aim of her persuasion was and how she did it. And Millie was thoughtful in terms of the strategy she'd employed to be persuasive. So I hope that's reassuring to our guests this evening that these aren't trick questions and you don't need any particular experience to answer them well. So thanks, Millie, for demonstrating that.
And from my perspective, Chris has actually said two of the points which I was going to raise, which was that you had a really good structure to your answers, particularly the argument question. And just to add to that, I think you were really unflappable when it came to the turning around and saying, right, now argue the other side, which is really what I think those questions are about. It's just not panicking when you're asked to then argue something completely different from what you've been saying before. And I also had a note that it was a really good example you gave, and I think just adding to what Clarissa said about that is that I actually think it would be more memorable to interviewers to have something that's drawn from everyday life rather than something that's perhaps connected to an example they might hear regularly, a moot that was won or a debate that was won or something like that. I think your example would probably stick in interviewers' minds more. And I think you gave a really good answer to what was a very tricky ethical question. Clarissa and I were discussing that ourselves before we came on the interview and weren't entirely sure of the answers we would give ourselves. So
no, but I have to say I really would just ring the ethics helpline. That is what I would do. So
well, what we thought might be helpful for people to hear is kind of that it's okay to say, I don't actually know, I'd go and ask somebody else for help, which they can perhaps take into any interviews they're doing to say, you know, that's what they might do. But you did also, you didn't just say that, you also gave an answer which was thought through and demonstrated the steps you would take. So not just taking what was said at face value and having a knee-jerk reaction based on that, but actually exploring it with them first before you take any further action.
Yeah, I think, I mean, I kind of did that a little bit on purpose because it's something I found that pupillage candidates who are really impressive do, is if they're not sure, or they say they're not sure, but they say, but these are the things I'm considering, and this is how I'm considering it. Showing that thought process is so valuable to us as interviewers, and I think you can feel very, very worried about doing it, but it generally is very helpful if done well and calmly, which is, you know, easier said than done when you're in an interview scenario.
Yeah, definitely.
All right, thank you. I'm sorry for the ethical question. I made it up. I don't totally know the answer to it when I suggested that ethical question. So thanks for giving me the answer in case that happens to me. So we'll launch into the Q&A now. If you weren't here at the beginning of the event, what I suggested is if you're too shy to put the hands up icon on, ask the question yourself if you feel comfortable to do so. But if you're too shy, you can just directly message me your question and I will ask the question for you. I have had a few questions already, and just a disclaimer that any advice that any of the panelists give is personal advice based on their experience. It's not necessarily a reflection of what their chambers does. It's not a reflection of what their inn does in scholarship interviews. So it's completely personal advice that's just provided to you to try and help during interview season. Okay, so questions. How can we best prepare for a legal problem where you're given documents in advance or asked to do a presentation or an advocacy exercise? Does anyone want to start us off on that?
I would get stuck in early, so make sure that you read it and give yourself time. And if you get it the day before, make sure you read it the day before so you get the chance to sleep on it. If you don't, then obviously you can't, but the sooner you read it, the better, and reread it because there's likely to be something that is perhaps not immediately obvious. That'd be my advice.
Yes, I totally agree with that. And then it's really going to be quite a personal thing for how you like to work. And, you know, there's not going to, what you're going to need to do is know whatever information you're given in advance inside out. And a huge amount of what will feed into a lot of our answers tonight, I suspect, is that a lot of what we're trying to understand in interview is how well you've prepared. It tells us how much you want the job and how much you're serious about our chambers. You know, Pupillage is competitive for you guys, but it's also competitive for us. We want to make sure that we get the best candidates and that we get people who are really, really invested in it. So a lot of the interview questions will be designed to know how well you prepare, that you've put some effort in, and that this sort of thing, you know, knowing all of the facts that you are given in advance, having looked at the cases you're asked to look at in real detail. Once you've done that, you can't really go wrong. You know, you'll have certain opinions on what's asked of you in relation to those materials, but you'll have done everything you possibly can if you know them inside out, or as much as you can within the time you're given. I think somebody in Chambers calls it making the papers sweat. So yeah.
To echo that and to address also the presentation element of it, if you're asked to prepare a presentation, think carefully in advance about how you're going to structure it, and practice. If you're asked to answer a question directly or a number of questions, make sure you know what your answers are and think about what the logical way to present that is. So if there are, for example, 3 points, you might say there are 3 key elements to this answer and signpost as you go through first, second, third. If it's a more complex answer where it's an if-then, you know, if this, then that, or if not, then that, you want to have thought through how you're going to talk through that answer as much as possible to make sure you're identifying all the points and signposting as you go. So you can make notes to support your preparation in whatever format is helpful for you, if that's a spider diagram, if that's bullet points. We all have our own ways of thinking about things, but I would think really carefully about structure if you're asked to prepare a presentation in advance, and a structure that you're going to be comfortable speaking to when you get into the interview. Don't be trying to memorize a speech, because if you try and memorize a speech, it's going to come across that you're memorizing a speech, and you might not remember it and you might freeze. What I'd say is think about what the key points are and the structure of how you want to deliver it. And that's what you should be trying to get in your head before you go in.
Right. Next question is related to what I mentioned earlier. Are you required to have an in-depth family law knowledge to complete and succeed in the sorts of exercises you get at an interview? So First of all, I don't want anyone to panic from Alex and Millie's interviews. As much as they try very hard to pretend they're not barristers during this event, they are, and they've been doing this for a while. So no doubt the quality of what they're doing is very different to what you'd be doing before you've actually started pupillage. But certainly from my experience, I swear I tell this story at every single event I'm at to do with pupillage. I don't think, certainly at first round, a lot of places will necessarily need you to have a really in-depth knowledge of the law. They'll want you to know about the key issues in family law because you're applying for a family law pupillage. So you need to be interested in the subject, and need to know the broad issues on the landscape and the family law landscape. But I remember having the audacity to turn up to a money interview at a specialist money set, and they went, a joint lives maintenance order is a meal ticket for life. And I paused for a really long moment and then went, what's a joint lives maintenance order? And then they explained it to me, and then I did my answer, and it can't have been horrendous because I did get through to the next round. So I think it's better to admit you don't know something than to try and hazard a guess at something and come up with something that doesn't make any sense at all. So that's my 2 cents. What does everyone else have to say?
Yeah, absolutely. I mean, it's really hard doing I did it last year around this year, and it's incredibly hard to try and pretend, I have been a barrister for 10 years. So the level of the intricate workings of the system, even knowing about position statements, honestly, we assume no knowledge whatsoever of family law, procedure, anything like that, even when our pupils start in chambers with us. That's our job, is to teach in pupillage. It isn't that you're expected to walk into the job day one. We know that isn't the case. Most of the time, interviews will be purposefully geared to that. Most people haven't done or have the opportunity to do a family law module on their GDL, so they might have done it on the bar course, but really the only experience is probably going to be a couple of weeks of mini pupillages, maybe, but even then we don't expect them to all have been in family sets, because the whole point of mini pupillage is that you get to go out and explore the different areas of law, and then you settle on doing family law later. So we shouldn't ask very much at all, beyond, like I say, the sort of topical issues of the day. I think the example of the cohabitees type dispute, that sort of policy, general discursive topic, we might expect people to have some views on, the kind of university level debate type topics, not tell us about a recent Mostyn judgment, unless of course we've given it to you in advance and asked you to read it.
I think it's also important to say that on a lot of those topical issues, there are people who are very experienced barristers who fall on both sides of the debate. So as long as you can form a cogent argument on one side of the debate or another, and like Malvika says, ask for clarification on what a term means or what an area of law is if you need it, then that's what needs to be seen as part of the interview, as sort of having an awareness that this is an issue and being able to form a cogent argument on one side or the other. And I just wanted to add that there are sort of resources that you can look at if you know you're interested in family law and you're going to be applying for family law sets. For example, there's Family Law Week that sends out emails that will keep you up to date with the issues of the day in family law, recent judgments, that kind of thing. There are also accounts on Twitter or X, whatever we're calling it these days, that keep you up to date with case law and things like that, and also barristers who will post their views on different issues. So there are easy and free ways to keep a general awareness of what are the topics in family law that you may well be asked about at interview.
Another resource thing, check out the Law Commission's executive summaries of their most recent projects, because they'll always pretty much cover, qualifying nuptial agreements, prenups, whatever we call them, cohabitees dispute. They go back years and years, the government never do anything about it, but there's great executive summaries being like, here are all the issues, here's what we decided. I mean, it's a pretty much a crib sheet.
If you are a Women and Family Law member, I will send an email out at some point this week with suggested resources. And if you're not a women in family law member, I'm going to try and do a thread on our Twitter at some point when I get a chance, pulling together some of these things that other people have mentioned. Question about what should you ask at the end of an interview, if anything?
Please,
I never ask anything. I
please,
never ask
only
anything.
what you actually want to know the answer to. Please, honestly, I cannot tell you how much we genuinely mean it as, if you actually have a question, then we'd like to answer it. But it's not a test. It is in no way part of our interview process. So don't feel that you have to be learned. I think sometimes people have asked us, what our view is on something. I mean, if you're genuinely interested in the panel's interview on something that you've discussed, it'll be like, oh, that was quite an interesting question. I just wonder what you actually think about that. By all means, carry on the sort of conversation. If you want to ask a practical question, by all means do, but please don't feel that you have to think of something to ask. It's absolutely fine to say, no, thank you very much. Thanks for inviting me for interview, and leave.
I think the question I asked was the question that Millie asked at the end, which is, when will I hear back? Albeit the only caveat to that is I was always told, if it is very clear on their website or in correspondence that you have been sent the timeline of events, then don't ask that, because it'll just show that you haven't read something that you were supposed to read. But that was the only real question that I would ever ask at the end of pupillage interviews.
I've been asked, within an advocacy exercise, for example, the anonymization question we did in Millie's interview, would you try and relate that back to family law, presumably if you're applying for a specialist family law pupillage, even if it isn't strictly relevant, or will those questions really just be about advocacy style and approach? Rachel?
I don't think I would make attempts to shoehorn something in if it isn't directly relevant to what you're being asked. I think it's much better to focus on the question that you're being asked and answer only the question that you are being asked. A bit like we tell clients when they're being cross-examined, don't use this as an opportunity to throw the kitchen sink at the question. Focus on what's being asked of you and answer that. If there's an opportunity to draw in something relevant, by all means, but if there's not, don't make an attempt at doing so.
I have a question which is specifically about the why barrister question, but it can apply to anything, I suppose. Should you give a new answer in an interview if you've already answered it in your application form? So why this Chambers, why family law, why do you want to be a barrister? If they ask it again in interview, but you've already answered it in your application form. Yes, Gwyn?
I think it's perfectly valid to give the same answers on the application form. You might want to flesh it out a bit, but if you've already answered the question, you might not guarantee that everyone on the panel has read the answer, maybe.
Some chambers try to keep them separate as well, so the paper sift is separate to their interview rounds. I don't know many that do that, but I know that some do it for sort of, I suppose, checking their own process reasons, that they do the paper sift entirely separately to the interviews.
That is true as well, yeah.
What I would add to that, though, is that although your reasons might be the same, the thrust of your answer might be the same, the way you deliver it shouldn't be. Written advocacy and oral communication are different, and you certainly shouldn't be memorising what you put on paper and re-delivering verbatim the same answer. And so I say it sounds silly, but I understand the temptation to have everything prepared and ready to go. And I think although your reasons should be the same, you should be answering in a much more conversational style.
Can you give some advice on answering the question, where do you see yourself in 5 years? I'm quite open-minded about where I end up in family law, and I find this a really difficult question to answer.
I part of my interview for my current chambers, and I just answered honestly, and I said, because at the time I was applying and did get a mixed common law pupillage, and I answered honestly that my main areas of interest at that time were criminal law and family law, but I wanted to try out different areas, and I anticipated that as I gained more experience in different areas, I would find the area that was right for me and that I would specialise in. And that over the course of time, what I would want to see was good instructions in interesting cases, and that I had a consistent workload that kept me motivated and engaged with my practice. And they obviously thought that answer was okay.
Yeah, I think what Charlotte's answer there actually really highlights is something that's a little bit overlooked some of the time in preparation for interviews and interviews generally, is that chambers sometimes want to see that you have got a sense of business, because ultimately you're going to be self-employed and you are going to need to bring work to chambers and to yourself. Obviously early on, you'll be very reliant on the clerks, but you could use this question to demonstrate a little bit of business sense and say, you hope that you've established very good relationships with your professional clients and solicitors, and just demonstrate that that's important. It's quite a hard question, because I think very few people have a really clear 5-year plan, or certainly, I don't know, I don't. But yeah, I think maybe demonstrate that, as Charlotte said, a little bit more of a business sense, rather than just sort of going, I want to have been in the Court of Appeal or something.
What is the best way to deal with a current affairs question when you don't really know the arguments on either side? Been there. I think I was asked about the pros and cons of North Korea having nuclear weapons, and a lot of waffle came out of my mouth in response to that question. Does anyone have any advice?
As always, don't panic and try and structure it. Also, I think a more generalized interview tip: if you have to pause for a minute, if you pause for 30 seconds, it will feel like it's been half an hour in your own head, but it won't feel like that to the interview panel. So just say, I'm going to take a minute to have a quick think about this and get my thoughts in order, or something, and just take a little bit of time. Even if you don't actually manage to get your thoughts in order at all, but you do just manage to calm down and not panic, that might help. Yeah, I think it's about how you go about answering the question in answer to almost all interview questions, more than it is what you say and exactly what your opinion is. So you can try and focus on that and think about coming up with a good structure, albeit you might find that your points are pretty broad brush at best.
This is a question about breadth versus depth. If you're asked a question like, for instance, what are the current issues facing the family courts and how can they be fixed? How would you go around answering that? Do you dive into the pros and cons of the issues, or keep it brief and sort of look at a macro level?
I don't think it matters. I think you can decide which approach you're going to take, and providing that approach is consistent, it doesn't really matter whether you are going at it in a broad brush sense and talking about lots of different issues, for example, or picking one or two and discussing those in depth. It's just about the way that the answer is structured, so that there's a sense to the answer, so that the arguments can be followed clearly and easily. So I don't think there's any right or wrong way to do it, but I think the importance is consistency.
And I suppose as well, you could always follow up if you were taking the broad brush approach by saying, here's my general overview, deal with that in a consistent and clear way, and then say to the panel, if you'd like me to develop on any of those issues, I can do so. And then if they want the depth, they can get that out of you.
What sorts of advocacy exercise can candidates expect? When I think off the top of my head, I had something very similar to the anonymization question. It might have been that, maybe that's where I got that from. But here's a topic, answer for, and now answer against. I think I had that a couple of times. I had you've got 10 minutes to read this judgment, and then tell us what the key points of this judgment are. I had here's a topical legal issue, something that came up in the press. to read in advance. Here's the article. Now give us a presentation on the issue that was about. Those were the sorts of things I had as advocacy exercises. And I had problem questions, which are slightly different. I'm so sorry. My niece has just barged into the... Kira. Anyway, she's in now. I can't get rid of her. So those are the sorts of things I had. Problem questions, I suppose, are slightly different to advocacy exercises.
Yeah, I think more and more chambers are using it's quite difficult to just assess how good an advocate is by asking advocacy exercise questions. So I think more and more chambers are using the general interview as an example of how good you are at explaining concepts, seeing things from both sides. You probably will get a for or against type advocacy exercise, but even I think recently we've been asking more sort of, here's a judgment, what did you think the key points of the judgment are? We might ask, did you agree? But I think we expect your advocacy to come through in all of your answers, and in particular if we ask a sort of, what's your biggest strength, what's your biggest weakness, the kind of classic interview questions that we expect you to have learned an answer to, essentially, or very much pre-prepared. I think those ones we're using really as a test of your advocacy, your, to some extent, eloquence and articulation, your ability to express ideas clearly. I think we're going to use the questions that we think you'll have predicted as an assessment, really, as opposed to a very distinct advocacy exercise.
I think there's less, in my experience, less specifically targeted family advocacy exercises like you might have in, for example, a criminal law set where you might be asked to do a bail application or something like that. It's, in my experience of doing interviews and people I've spoken to, that's less common in family law. The only thing I could think would be really amenable to that sort of exercise would be perhaps an application for a non-molestation order. But I would think that it would be fairly likely, if that was to be done, that there might be some supporting material provided around that, perhaps reference to the law and the test and things like that. It's more common that you would have the sort of, here's a general topic, present on that. So in one interview I did, I arrived, was given a topic sheet with, I think, 4 or 5 topics on, and they said, choose one. You're going to present this to us for, I can't remember the amount of time, but a few minutes, which were as general. I remember one that has stuck with me to this day as being, do you prefer ketchup or brown sauce? Now, I didn't pick that one, but it could be as general as something like that.
I think there's probably a very big difference between what's expected of you at a first round interview where you've been given a couple of minutes to consider your answer, and when you've been given some material to prepare beforehand, and you had an awful lot of time to think about how you're going to present yourself. Okay, I think we are almost out of time. So last question, and I'm going to ask each panelist to answer this. What are your pet peeves when interviewing applicants? Now, I don't know if everyone here is on a pupillage panel. I'm not. But you've probably interviewed or done mock interviews or done some form of interviewing somewhere. So what do you think those are, or what are the most common mistakes that you've seen?
Waffling is not good, and also something that I think Zoom has brought about, which is people not knowing when to stop talking because they don't get natural body language back, but just keep it punchy.
Millie?
You'd be amazed how often people can't give us a really genuinely individual reason why our set of chambers. We know, I promise you, we know you're applying to 30 sets of chambers, and certainly we know which family sets you're applying to. And you'll see everybody at the interviews, you'll get to know who the other family pupillage candidates are, but please have some good reason why, if you're in front of me, why 1KBW. You know, what is it about 1KBW that you have read on our website or on our Twitter page immediately prior to this interview that you have been persuaded by to join our set? I mean, we know it's artificial to some extent. If you haven't done a mini pupillage with us, then it will just be based on what we've recently put online, but please have read it and please have a good individual reason. You know, it shouldn't take you 5 minutes, but it's infuriating when it feels so generic, and we'd probably ask you that question. Why wouldn't we?
Yeah, I think it's really hard sometimes to answer that question, because the Chambers website puff about what they do is, we are specialists in these 374 areas of law, when actually probably a quarter of a person in that Chambers actually does that really niche area of law that they mention on their website. So be warned by saying, oh, I'm really interested in international child abduction, when actually hardly anyone in that set does that.
So, I suppose I should be more specific. You should, you know, go onto Twitter and say, you know, oh, well, I was reading this case and then I looked at the barristers involved and I saw that, you know, both sides were 1KBW, or just come up with some little thing. It should only take you 5-10 minutes, but, you know, try and, if you bumped into somebody at a pupillage fair and they were at the set that you're at, say they were amazing, whatever it is, just have something that directly relates to that Chambers and isn't, you know, actually about one of their key competitors. In applications, paper applications, I promise you I still see, I'm applying for pupillage at 42 Bedford Row, I'm applying for pupillage at 4PB. Please, please sort it. And it just immediately, it's a no, and it's such a shame.
Clarissa?
I'm not wanting to repeat what's already been said. I think that something that grates both when it's written in application forms and in oral interviews is exaggeration. I've always been interested in law since the minute I was born. You don't need to have always been fascinated by these things. I think sticking to your own experience is really important and comes across better. If you know you only discovered family law in recent months, or you be honest about your own journey. You don't need to have always been fascinated by family law or been wanting to be an advocate since you were small. I think really understanding people's journeys is part of what the interview process is about.
Rachel?
I would agree both with Millie and Clarissa. Do your research, it's essential. I have read both paper applications and been in live interviews where people's responses are very clearly generic ones that are being trotted out at every opportunity, and it really shines through. And also in terms of what Clarissa has said, don't be afraid to highlight the things that are individual about you. Don't feel that you have to fit a certain mold when that's not your experience. Try and be as authentic as you possibly can.
Charlotte?
Most of the points have been taken, but I'm going to piggyback, I think, on Gwynfor's point and say a lack of structure in answers, because I think people are sometimes a bit scared of just doing the classic, I'm going to make 3 points. Here's point 1, here's point 2, here's point 3, because they worry it comes across as boring, or we're not going to think you're the most inventive advocate in the world. But actually, it's so much easier to follow when you're listening to an answer if you go, here's my 3 points. Then they make those points, and you can, and it's a lot easier to piggyback off that with your next question if you want to do so. So in response to point 2, you said this, or, you know, I would just say it's better that you come across as clear and concise than perhaps slightly boring in your presentation style, because that's something you will develop as an advocate as you go through your career. Whereas being hard to follow, you're going to lose your interviewers immediately and they're just not going to listen to everything that you have to say.
And mine is not answering the question that you were asked and answering the question you wish you were asked, because you've probably practiced so many times what you're going to say, and you're really, really keen to tell the panel that particular thing, but that's not actually what they asked you. So that's mine. So thank you everyone for joining. Thank you so much to our panelists for volunteering again. I just got a message from Clarissa saying I would have lapped this up if I were a pupillage interview candidate. Me too. And it's always incredibly helpful for everyone every single year. If you have any feedback, please email us at admin@womenandfamilylaw.net. I will try and set this recording up at some point and advertise that it's up on our YouTube, and I will try and send a link of resources as well that you might find helpful when preparing. But best of luck to everyone. We really hope you do fantastically this pupillage interview season, and thank you so much for joining. I'll let you all enjoy the rest of your Tuesday evening. Thank you.